Welcome once again. Now, only a few hours to the March 18th gubernatorial elections, the Federal High Court in Abuja has ordered the Independent National Electoral Commission (INEC) to allow the use of temporary voter cards.
The order was given by Justice Obiora Egwatu last week while delivering judgment in a suit filed by two Nigerians seeking the use of TVCs or temporary voter cards in the general elections when permanent voter cards or PVCs are not available. According to Justice Egwatu, the order was made on the grounds that the plaintiffs had been duly registered and captured in INEC's database prior to the commencement of the general election. The judge, however, said he was unable to grant prayer 3, which was to allow every eligible voter with a TVC to vote because the suit was not filed in a representative capacity.
Well, to give us more insight and to correct, any misinformation being spread as regards this judgment from various quarters is Opatola Victor. His the lawyer representing the plaintiffs in the recent judgment. Good morning. Thanks for joining us. All right, can you help unmute your device so we can hear you?
Not mute, actually.
All right, brilliant. Thanks for joining us.
Can you hear me?
Yes, we can now. Please tell us what exactly this order means, in essence, and, what INEC's response has been so far.
Okay, this judgment is a landmark judgment in electoral jurisprudence in this country. Over the years, a lot of persons have been trying to achieve parity when it comes to the use of temporary voters card and permanent voters card in election, due to the fact that every electoral cycle, millions and millions of people are systematically disenfranchised because of the system put in place, because of the discrepancy between the permanent voters card and the temporary voters card. Sometimes in February, my client, through me, approached the court to determine their right to use a temporary voters card to vote, minding the fact that the INEC has ended or closed the collection of permanent voters card. In the court making this decision, like we argued that there is no law that makes a discrepancy between the permanent voters card and the temporary voters card. And the INEC regulation, which stipulated the use of the permanent voters card, is a subsidiary legislation that cannot override the Enabling Act, which is the Electoral Act 2022 and the 1999 Constitution. So basically, the judgment was given. And when judgments are given, what is important is the principle enunciated in the judgment. In page 20 of this judgment, the court held that anybody who has fulfilled the legal requirement, and ensure that he or she has been registered by INEC and contained in the INEC database, and has been issued a temporary voters card and given a voter identification number, is entitled to vote. And the negligence, ineptitude of INEC should not disenfranchise such person. Now, it is true that two persons went to court in this matter, but what is important is the principle enunciated by this judgment. There is a principle of law which says equality is equity. INEC does not have the power to pick and choose whose right to violate and whose right to uphold. This judgment was gotten by two individuals, but millions and millions of Nigerians are also in the same shoes, facts and law, as these two individuals. So INEC cannot just uphold these two people's rights and neglect or fail to uphold the right of millions and millions of Nigeria who have fulfilled all legal requirements to get their permanent voters card, but due to the inefficiency of INEC, couldn't get their permanent voters card. Now, let me state very clearly, there is no discrepancy between the temporary voters card and the permanent voters card. People do not understand that the beavers machine is not the card readers machine. Prior to this election, what we use is the card readers machine. The card readers machine, which was used, for instance, in 2019 election, requires the plastic nature of the permanent voters card in order to verify a voter. That means in 2019, we needed to insert the plastic permanent voters card into the card reader machine in order for you to verify the voter. But because of the beavers, you don't need to insert the permanent voters card. As a matter of fact, the beavers machine verifies an intending voter in 3 different ways. These 3 different ways, any of these 3 different ways is sufficient you do not need to be verified in all of these 3 different ways I will mention. The first one is through your surname. The BVAS machine can successfully verify an individual, an intending voter, through his or her surname alone, and that will suffice. The second one is the verification through your voter, the last few digits of your voter identification number. The BVAS machine can verify you through your last few digits of your voter identification number alone. The third way
seems we might have lost connection to Mr.
Is true.
Okay.
The third way is through your. I can hear you.
All right, please
go ahead, please.
Okay, so the BVAS machine can verify you through your barcode alone. So these 3 things that I just mentioned, the BVAS machine can use any one of these 3 things. Then after verification is accreditation. This is the accreditation that will use your thumbprint or your facial recognition. Let us mind the fact that no 2 persons have the same thumbprint. So the issue of card reader or BVAS machine does not arise. What we are using now is BVAS machine. And what the BVAS machine needs is not the plastic nature of the permanent voter's card. What it needs is your information alone. With your surname, it can successfully verify you and you can vote. Now, there's been various arguments as to the reluctance of INEC not to allow or not to stand by the court judgment and be in contempt of the court. Some persons have argued that it is due to the economic angle of the printing of the permanent voter's card, that some persons are behind the billions and billions of contracts of printing the permanent voter's card, and it is an entrenched economic interest. I will go to the issue of appeal. Just yesterday, we were served with a notice of appeal and the stay of execution by INEC. Just yesterday. And let me quickly state, in law, every lawyer knows this. A stay of execution or a notice of appeal, it is not or does not upturn the judgment. The judgment of the Federal High Court still stands. It is valid, it is subsisting, it is the law as I speak to you today, until it is upturned by the Court of Appeal. And they just served us a notice of appeal just yesterday, which is, I think, 16th of March. They just served us yesterday. So there cannot be a judgment of Court of Appeal between today and tomorrow, which is the election. There cannot be an order of stay of execution between today and tomorrow, which is election. So we call on good people of Nigeria to place a clarion call on INEC to abide and uphold the tenet of democracy and stand by the court's judgment. The principle of democracy is a very fundamental principle of our election. An important part of this principle of democracy is free and fair election,
exactly,
which is aided when people go out en masse to vote.
And now that you're speaking, you've spoken about this principle of free and fair elections, talking about people going out en masse to vote. We have about 24 hours to the elections, and you've really stated categorically that whilst you've taken your stance and the court has taken its stance, that INEC unfortunately has appealed for a stay of execution. We can't find out what the details would be between yesterday and today. So we're just going to have to wait and see what happens at the polls. But we thank you so much for sharing your time with us.
Before you go, quickly also share with us, how much of a difference will it make? In the last elections, we saw 93 million, I think, full registered voters, and of course eligible was 87 million, I believe. Does it mean that if INEC allows this to happen, we'll get more than 100 million people come out to vote?
Okay. Now, let me first start from your colleague's discussion in regards to the appeal. Like I said earlier on, the fact that they filed a notice of appeal does not mean judgment will be given between today and tomorrow. Their stay of execution is INEC. In their stay of execution, they were praying the court to stay this judgment pending the determination at the Court of Appeal. That's the content of their stay of execution. Now, going to your question, this decision, like I said, is a landmark decision. First of all, it will impose trust in INEC by the people if INEC uphold and stand by this decision, because people will believe INEC is on the side of the electorate to ensure that they come out to vote en masse. Now, when people can vote with their temporary voters card, let us cast our mind back a little bit, where we see millions of permanent voters card who were just discarded. Some millions of people, INEC came out to say that millions of people have not been able to get their permanent voters card. That means that once the use of temporary voters card is officially allowed by INEC, it will increase drastically the numbers of people who come out to vote. Let me state very quickly, the last presidential election, just concluded presidential election, it was said that the turnout was around 35%, which is woeful. 35% out of 100% is a woeful figure. The numbers of people who come out to vote is also a means of conferring legitimacy on the present government in power. So let people come out to vote so that then INEC can allow them use their temporary voters card.
Absolutely. Now, let's also bring you in on this. There's a video that appears to be shocking to a lot of Nigerians ahead of the elections tomorrow. But that video, of course, has circulated online. With barely 24 hours to go, the chairman of the Lagos State Park and Garage Management Committee, Musliu Akinsoya, popularly known as MC Olomo, is heard in this video making a very shocking remark by warning residents in the state that would not vote for the All Progressive Congress on the 18th of March election to sit at home. So let's quickly, get our viewers to watch this, and then we'll have you react to this.
Okay, thank you.
Táwọn wá dìbò tán, táwọn òwòrán yìí pé a ti bẹ̀yìn, ẹnì sọ pé ẹ ti gbọ́, tẹ́lá ti ṣe mistake, ó má ti yé yín, tẹ̀sí ní pé mistake ti ń ṣẹlẹ̀, lọ́dọ̀ tẹ̀pẹ́ ilẹ̀ ní ìdìlọ́wọ́, ẹ ti yé yín.
Oh, well, let's quickly get your views on that, that video.
Okay, now it is fundamental. Any word of truth, any word that encourages voter suppression is an offense. As a matter of fact, it's a criminal offense under the Electoral Act, probably Section 93, thereabout. Any word of threat to voters, it's a criminal offense under the Electoral Act. So what he has said, I didn't hear clearly what he has said, but if what he has said is threatening voters, or encouraging voter suppression, the extant position of the law is that it's an offense under the Electoral Act, this present Electoral Act. So the police can do well to probably just put certain things in place to ensure that there's no mayhem in tomorrow's election. And importantly, people that make this incendiary comment, that make comments such as this, should be careful, because they can be prosecuted for offense such as this.
Yeah, absolutely. And let me just quickly share with our viewers what the Electoral Act says in Section 93, like you mentioned. It says here, a party, candidate, aspirant, or person or group of persons shall not directly or indirectly threaten any person with the use of force or violence during any political campaign in order to compel the person or any other person to support or refrain from supporting a political party or candidate. It goes on to say that the political party, candidate, aspirant, person or group of persons that contravenes the provisions in this section commits an offense and is liable on conviction, in the case of a candidate, aspirant, or person or group of persons, to a maximum fine of 1 million naira or 12 months in jail. Yes. In the case of a political party, to a fine of 2 million naira in the first instance, or 500,000 naira for a subsequent offense. I mean,
yes.
So I don't know. I mean, I think Olive may also want to chip in here, because my thoughts here might be very, very bad. But I don't know if you think that these act needs to maybe be adjusted, because is it the lack of laws to punish offenders,
or
its lack of exactly of implementation of these laws? Does the Nigerian police or the Nigerian security service, are they complicit in situations like this?
No, you see, this is it. There are laws, and the issue of implementation need not arise again. The Supreme Court in a 2020 case has allowed individuals to prosecute criminal cases, except for murder instances or capital offenses. So, for instance, in section 262 or 263, thereabout, of Administration of Criminal Justice Act, individuals can prosecute a criminal offense by themselves or by their lawyers. In section 301 of the Administration of Criminal Justice Law of Anambra State, this is also applicable. So once you have your evidence and you probably do not believe the police might take it up or they might be slow about it, you as an individual, you can, prosecute it, get your evidence and prosecute it in the court of law. So the issue of the days of waiting for the police to make prosecution is far gone.
All right.
The Administration of Criminal Justice Act has enabled individuals, and the Supreme Court has interpreted these sections. So individuals, when you feel individuals can prosecute offenses under the Electoral Act 2022. So now it is no longer the issue of there's no law or the issue of execution, because individuals can actually execute.
All right, Opatola Victor, thank you very much for your time. We will like to have you back again. We hope that we're just going to have to wait and see if INEC obeys the court order, or if they decide to follow through with their own stay of the execution of judgment. Which
they follow through? No, please, let me just state this very clearly.
Okay.
There's no follow through. A judgment is a judgment. You must stand by it. That is the rule of law. You must stand by it. And INEC, as a paramount independent institution, must stand by rule of law and democracy in this country. So people should call on INEC to make INEC stand by the judgment of the court. If not, INEC will be in contempt of court. Thank you.
Thank you very much, Opatola Victor, for joining us this morning and sharing these these conversations with us. We do look forward to having you again after the elections. Hopefully, you'll be in better circumstances.
Thank you very much.